a spousal property petition. And this is a petition that the surviving spouse can file with the court. They are basically asking the court to confirm that assets that were owned by their now deceased spouse belong to them as a surviving spouse, that they are entitled to it either because they were the beneficiary under their spouse's will or because as their spouse, they are their heir and therefore entitled to the property. It's still a court procedure, but it's not nearly as bad as probate. It's a streamlined process for surviving spouses.
Right. It's not as long or complicated and therefore expensive. Usually complicated means expensive when you're talking about attorney involvement. It's not as complicated as a probate. Typically, we just file the one petition. It's called a spousal property petition. We have to give notice to a variety of other possible heirs and beneficiaries like the children. And we get a hearing date when we file our petition. And anybody who wants to object is now allowed to file some kind of an objection prior to the hearing date or come to the hearing and state their objection. And then we attend the hearing on behalf of our client, who would be the surviving spouse. And if there are no objections and there's nothing wrong with what we've submitted to the court, the judge will sign an order that says this property, and they'll list out the various things, now belongs to this surviving spouse.
Now, last time we talked about the small estate affidavit, and we said that that could only be used if the total value of the assets was under the probate threshold, which is $184,500. Is that also the case here?
So no, that's a very important point. The spousal property petition can be used for anything that is either left to the surviving spouse without a trust or inherited by the surviving spouse under the rules of intestacy. It doesn't matter the value. Anything the surviving spouse is claiming can be put into a spousal property petition. But I guess that also brings up the point that if it's under $184,500, the surviving spouse is just going to go ahead and do a small estate affidavit. They're not going to bother with this court process. They're only going to do it if it's above that amount.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcounsel.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcounsel.com/scheduling. Don't forget to keep an eye out for our next live episode. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcounsel.com. Thanks again for listening. We'll see you soon.